business company is just like any ordinary company. It is generally a company which is limited by shares, and it is one of the two types of companies in Mauritius that may be set up by a foreigner to conduct international business activities, that is business outside of Mauritius. As I mentioned in my introduction, the global business company was formerly known as the GBC1, but following a report in Mauritius, it is henceforth known as the GBC, and there used to be a second type of global business company, which was called the GBC2, that has now disappeared and has been replaced by the concept of an authorized company. The choice between a global business company or an authorized company depends principally on whether the activity that is to be undertaken from Mauritius is a financial services activity, or whether the entity needs to be present in Mauritius, principally to benefit from double taxation agreements. So where a client wants to undertake either a financial services business from Mauritius or needs a company which is tax resident in Mauritius, it must be structured as a global business company. However, if neither financial services business activities are contemplated, nor access to double taxation treaties are required, then an international client could also consider the use of an authorized. So for the purposes of this masterclass, incorporated under the Companies Act, which is the law that applies to company. The Act was passed in 2001. It is a very modern piece of legislation. It's based on the New Zealand Companies Act, which is largely regarded as one of the most modern pieces of legislation on company law. And it is a company that is resident for tax purposes in Mauritius. Obviously, it has to comply with certain requirements. We'll come to that later. But the main difference between a global business company and a domestic company is that a global business company is established principally to conduct business outside of Mauritius and is also ultimately owned or controlled by a person or persons who are not citizens of Mauritius. So if the intention is for the company to be owned or controlled in majority by people who are not citizens of Mauritius, and the purpose for which that company is being set up is to conduct business outside of Mauritius, it needs to be structured as a global business. Now, there is not, if the client wants to use a GBC to conduct a business for which a license is required, and very often this is the case for financial services business activities. Over and above the GBC license, a separate license would also be required. So a GBC which intends to conduct non-licensable business activities does not need a separate license. The GBC license in itself is enough. But if the GBC wants to conduct a financial services business on top of the GBC license, it will also need to apply for the relevant financial services license. We will have the opportunity to come back later on uses of the GBC. The majority of GBCs that are set up in Mauritius for non-licensable activities are set up to conduct cross-border investments. So very often they would be established as holding companies, whereby clients would wish to invest in Africa, for example, or India, and find it very beneficial to do so through a Mauritius investment company that is structured as a GBC. The use of such holding companies is very common and very popular amongst investors. Very often, you would also see that this is the preference of development financial institutions to hold and manage their equity participation in subsidiaries across the world through a holding company. And there are many reasons for that. And as I mentioned before, it is really in order to benefit from the ecosystem that the International Financial Center is able to provide. For example, Mauritius has become really a hub for the establishment of investment holding companies for the purposes of investing in Africa. And one of the main reasons for that is because in doing so, investors are able to mitigate their risks. Because of our legal system, our regulatory framework, there is a lot of risk mitigation that can be done by making use of a holding company in Mauritius. And therefore, it's no surprise that over the years, Mauritius GBC has proven to be a very compelling proposition for asset protection, for risk management, for investors. And very often, these holding companies would be used as a sort of umbrella to hold different operating subsidiaries and companies in various parts of the world. And if you look at the statistics, you will see that a lot of these operating companies and subsidiaries are in emerging economies, economies where perhaps a direct investment would have made it more prone to various types of risks. And over the 2 decades, it would be fair to say that Mauritius has emerged as the ideal international financial center to establish cross-border investment companies for doing business in Africa. A lot of international investors, development financial institutions, sophisticated investors use Mauritius as an investment hub for their cross-border investments in Africa. And there are many attractions for doing so, as I alluded to earlier on. So cross-border investment is probably one of the main users for global business companies. Obviously, global business companies can also be used for other types of activities. And here, I think mainly of activities that are in the nature of financial services activities. So, for example, a lot of private equity funds, especially those that have been established to invest in India or to invest in Africa, are also established as global business companies. Similarly, fund managers are also established as global business companies. And the legal framework has a number of different types of licenses that may be availed of by international investors who would like to undertake a financial services business from Mauritius. And I only mention a few. Asset management, for example, especially in the context of private wealth. We see that there is a lot of interest for international investors, international clients to make use of Mauritius as a base to undertake wealth management services for clients in Africa. Again, a GBC company would be ideal for that type of business. Global headquarters as well, global shared services, global treasury activities, leasing, peer-to-peer lending, crowdfunding activities are all those types of activities that would lend themselves very well to a global business company. Last but not least, global business companies can also be used to undertake global trading activities. Now, this is an activity that is now subject to a flat rate of taxation, which is now at 3%. So a global trading company is a company that is engaging in export of goods. That includes international buying and selling of goods, whereby the shipment of such goods can be made directly by the shipper in the original exporting country to the final importer in the importing country, without the goods being physically landed in Mauritius. And this type of activity can also be structured through a global business company if the majority shareholding of that company will be followed. So, in a nutshell, in terms of uses, I deliberately chose to focus on three broad types of uses: cross-border investments, financial services business activities, and global trading activities. GBC can be set up as a public company or a private company. It could also be specifically structured as a limited life company or a protected cell company. A protected cell company is, for example, very common when the activity is that of captive insurance. It is very common for a captive to be set up as a GBC protected cell company. A global business company cannot deal or transact with Mauritian residents because, as I mentioned before, the purpose for which that company is set up is to undertake global business. However, there is always the possibility of getting a special approval from the regulatory bodies, so long as the Mauritian segment of the business is ancillary to the core business. So GBCs should primarily conduct global business, but could potentially also undertake Mauritian business if it is ancillary to its core business. Such a company will need to open and maintain a bank account in Mauritius. It needs to comply with a number of substance requirements that we will cover shortly. It can invest in securities which is listed on the stock exchange. It is normally structured as a private company limited by shares, although you could also structure it as a company limited by guarantee. And interestingly, Mauritius did away with the concept of par value in 2001. So if it is structured as a company limited by shares, shares may be issued with or without par value. And if the client wishes to issue shares of par value, it may be issued and stated in really any currency. Right? It's got a requirement to prepare audited financial statements that must be filed with the regulator within 6 months of its financial year end. It may prepare it with either international accounting standards or in accordance with any other internationally accepted accounting standards. It must file its annual tax return with the Mauritius Revenue Authority within 6 months of its balance sheet date. It has no requirement to have memorandum or articles of association. Again, this is something that we did away with in 2001. The companies that are set up in Mauritius could elect to be governed by the Companies Act. So therefore, there is no requirement to have a memorandum or articles of association, which is called under Mauritian law as a constitution. But if shareholders want to have a constitution, they can always adopt one. There is a requirement to keep various types of records in Mauritius, including minutes of meetings or resolutions, accounting records, the share register, the register of directors, etc. Because it is a company which is resident in Mauritius, and therefore there is a need to keep proper records. It's important to note that the GBC register of directors and beneficial owners are private and are not accessible to the public. Although recently the law was changed so that the register of directors for a GBC is now part of public record. And there are also various other statutory requirements which you would normally find in all jurisdictions in terms of filing of changes and so on and so forth. So that's in a nutshell the features of the global business company. Let's now turn to a very important aspect of global business companies, and that's to do with substance requirements. As a lot of you would know, there has over the years been a gradual shift from form to substance. It used to be the case that so long as a company was established and incorporated in a jurisdiction, it was deemed to be resident, especially from a tax perspective in that jurisdiction. Over the years, more and more emphasis has been put on the requirement of substance over form. So it's no longer acceptable for clients to simply set up a company in a particular jurisdiction and benefit from the tax residency in that jurisdiction unless that company also complies with substance requirements. Following the OECD BEPS report, or BEPS, as some of you would know, stands for waste, erosion, and profit shifting. A lot, in fact, all international financial centers have had to beef up their substance requirements, and so has Mauritius. And therefore, if an international client wants to set up a global business company in Mauritius, it must comply with substance requirements. So what are those substance requirements? Now, there are three main components to the substance requirements. The first component is the core income generating activities, or SIGA, as some people would call it. A GBC must carry out its core income generating activities in or from Mauritius. So if we take the example of an investment holding company, it is very important that that activity is seen to be carried out in or from Mauritius. Secondly, the company must be managed and controlled from Mauritius. And thirdly, the global business company must be administered by a management company like Axis. And in terms of the management and control test, there are a number of requirements in order to comply with the test for management and control. For example, every GBC must have at least 2 directors resident in Mauritius who must be of sufficient caliber to exercise independence of mind and judgment. Mauritius does not recognize the concept of a nominee director. We never have, and we will never do. And therefore, every director has the same powers, the same responsibilities, and potentially the same liabilities at law, whether it is an independent director or a director who happens to be the shareholder himself or who is connected to the client. And that's very important because very often clients assume that the Mauritian-based directors are nominee directors. No, they are not. They are directors in their own right and therefore shall be expected to discharge their fiduciary duties. The second requirement for control and management is the bank account. I mentioned it before. A GBC must have its principal bank account in Mauritius. Thirdly, it must maintain its accounting records in Mauritius. Fourth, it must prepare its financial statements and have them audited in Mauritius. And also, very importantly, it must ensure that the decision-making is seen to be made from Mauritius. And as we know, when it comes to a company, it is the board that takes decisions. So therefore, very important for meetings of directors to be seen, to be conducted in Mauritius. It is possible for directors to participate by teleconferencing and other methods, but it must be shown that the majority of directors are from Mauritius, because otherwise there can be a risk that the company may be seen to be controlled and managed from somewhere else. So that is generally the sort of rules that apply in the context of substance, and be issued with what is called a TRC, a tax residency certificate. This is a document which is issued by the Mauritius Revenue Authority. And there is case law, Indian case law, to the effect that a TRC that has been issued by the MRA is conclusive evidence that the company is indeed resident for tax purposes in Mauritius. And therefore, this is a very important document which goes a long way towards demonstrating tax residency. So a GBC which is tax resident in Mauritius will be subject to taxation at the normal corporate tax rate. I mentioned earlier on that there is no distinction anymore between the tax framework for domestic companies and GBCs. They've been aligned, and both the GBC and the domestic company are subject to the corporate tax rate of 15%. And there is an exception to that. I mentioned it before. If the GBC is conducting global trading activities, then it will be taxed at a flat rate of 3%, but that's also applicable to domestic companies that are doing the same activity. A GBC can either use the tax credit system or the partial exemption system, which eventually will lead to a reduction in the headline rate of 15%. So that is a choice, depending on the circumstances. The tax credit system is very simple. If the income that is derived by the GBC has been subject to taxation, before it is remitted to the Mauritian company, and that also includes underlying income, then the tax paid can simply be offset against the rate of 15%. Depending on the amount of tax that has been paid, that will reduce the tax. So, for example, if the income has been subject to 15% or more tax before it is earned by the GBC, then the GBC will not be subject to any taxation in Mauritius. Alternatively, a GBC and a domestic company could avail of a system called the partial exemption system, the effect of which is to grant an exemption of 80% on certain types of foreign source income. And this is a limitative list, right? Only certain types of income are covered by the PER. What is more relevant to GBC companies is dividends and interest, because most GBCs, as I mentioned earlier, are established either to hold equity participations or to provide debt. You will be very pleased to know that foreign dividends derived by a GBC and foreign source interest that are derived by a GBC are subject to the partial exemption. And there are also other types of income derived from ship and aircraft leasing activities, income derived by a foreign permanent establishment, income derived from collective investment schemes, closed-end funds, CIS managers, CIS administrators, etc. Certain types of income derived from reinsurance activities, leasing activities are also covered by the PER. But very often, the three that are going to be most, would be of interest to you generally would be the dividend income, interest income, and income from CIS activities, investment manager activities, and so on and so forth. And these are covered by the partial exemption system. So a company which is resident in Mauritius, which has got a tax residency certificate, would be able to benefit from the partial exemption system. They also need to demonstrate, as mentioned before, that they have the required amount of substance. And when it comes to substance, there are various rules that apply depending on the type of activity of the company. For example, if it is a pure equity holding, then the substance requirements are less. If the company is undertaking financial services activities, for example, then there are added requirements. For example, there would be employment requirements, which can be direct or indirect, and there will also be expenditure requirements. Obviously, we would not have enough time in this presentation to go into the details of how these work. Just to conclude on the issue of taxation, I think it's also good to know that GBC will not be subject to capital gains tax. In fact, we do not have capital gains tax in Mauritius. So therefore, where a GBC is making a capital gain, say from the disposal of certain underlying assets, there will be no capital gains tax in Mauritius. And also, it will also be worth noting that Mauritius is a treaty-based jurisdiction, and under all but one tax treaty, it is Mauritius that has a right to tax gains upon a disposal of assets in a treaty country, and therefore, upon such a disposal being made, there would be no capital gains tax that will be levied. The only country where that is different is India. Some of you would know the Mauritius-India Treaty was amended a few years ago, and it is India now that has a taxing rights in respect of capital gains tax. We also don't have any withholding tax in Mauritius on the payment of dividends, interest, or royalties. Free repatriation of funds from Mauritius. So once the company has decided to distribute upwards, upstream, there is no other tax or liability that will apply further to that distribution. So therefore, I think to sort of conclude on the issue of taxation, through the use of the GBC, you don't only benefit from a relatively low tax base, as I said, 15%, but potentially anything between 0 to 3%, either through the application of the partial exemption system or through the actual credit system. But I think the cherry on the cake is that because we are a treaty-based jurisdiction, there are added benefits to be gained from the various the vast network of double taxation agreements that Mauritius has with a number of countries, but more specifically with a lot of countries in Africa. And when a treaty works, I think I mentioned the capital gains tax benefit already, but there are also benefits that go beyond capital gains. In most treaties, withholding taxes will also be reduced as compared to the rate that are applicable in the country of source. So very often you have a reduced withholding tax rate, which therefore also makes it quite appealing for using Mauritius as a platform to invest in treaty countries. Obviously, tax should not be the main reason why Mauritius is used, because it needs to also be shown that there are also non-tax reasons as to why an investor is using Mauritius. But as I mentioned before, our experience is that tax is only one of a number of factors that people like yourself look at when they are deciding where to establish a company to undertake global business. So to conclude, really, I just want to say a few words on the process. We've talked about the reasons why clients like to use international financial centers to set up such type of companies. We've talked about the potential uses of the GBC. We've talked about the features. We've talked about taxation. Let's now spend just a couple of minutes on the process, because I'm sure you would want to know, if you wanted to set up a GBC, how do you go about it? Well, like any other company, it goes through a formal incorporation process. The law requires that a global business company's incorporation and licensing should be channeled through a licensed corporate service provider like us. So it's a simultaneous process of applying for incorporation with the registrar of companies and applying for a license with the Financial Services Commission. The time frame to set up the GBC, provided that it does not also require an additional license, is between, I would say, 14 to 21 days, right? Depending on the complexity of the structure and the activities involved. If it is a financial services business, it would take between 4 to 6 weeks, right? That's basically an indication of the time frame. There is obviously a requirement for due diligence. That is very important. So there is a formal onboarding process where Axis as a management company would need to obtain the necessary verifications on the fitness and propriety of the client, but also on the source of funds. The framework, especially for anti-money laundering and prevention of terrorism financing, places an onus on us to actually filter applications, to ensure that people who are coming to Mauritius to undertake global business are not going to use Mauritius as a platform to undertake illicit activities. So there is a duty of due diligence at the outset, but that duty doesn't end there. The reason why every GBC needs to have a management company at all times is because we also have a responsibility throughout the relationship to ensure that all transactions that are undertaken through that company are transactions that are legitimate. We do that by being on the board of the company. I mentioned the requirement of local directors. We do that by being the secretary of the company. We do that also by monitoring transactions so that we are able to detect any suspicious activity. And where there is a suspicious activity, we have a duty to report it through what is called a suspicious transaction report. So the role of the management company is very important in the context of the prevention of money laundering and of terrorism financing, which has now, acquired an even, it's even more important now in the context of added obligations on international financial centers in respect of AML CFT. To conclude, how can we assist you? Well, if you would like to set up a global business company, we have a highly experienced team that will handhold you throughout the process. We have the relevant expertise in advising you, especially through our association with a leading law firm in Mauritius, BLC Robert, on how to properly structure your business in order to accomplish your goals and optimize your benefits. We offer what we call a one-stop shop solution to you. We can assist you in all your needs involving your structure in Mauritius from inception and throughout the lifespan, the life cycle of your business. We would normally be responsible for working with you to prepare the application that would be made for the company's incorporation and for its licensing and for following up with the regulatory authorities so that the GBC is eventually set up. And once it is set up, we will provide you with all the necessary corporate, secretarial, administration, accounting, and other ancillary services in order to ensure that the company is operating in line with the requirements of the legal and